Here in appeal of Skatteforvaltningen against MCML Ltd, previously known as ED&F Man Capital Markets Limited.
Yes, Lord Paddock. Good morning, my lords, my ladies. I appear with Charles Graham and KV Krishna Prasad for the appellants, who are Skat, the Danish Tax and Customs Administration, and the respondent is represented by my learned friends Mr. Ali Malik, Adam Temple and John Yap. And at the time of the events which are the subject of this appeal, the respondent was known as EDFM, which is what we've all called them. The court will have seen this appeal concerns the scope and the application of the principle of issue estoppel. And in very brief, but I hope sufficient summary of the background, can I say this? Skat brought claims in 2018 against a large number of defendants, including EDFM, and the allegation was that Skat had been induced by misrepresentations to pay out very large sums. They totaled the equivalent of £1.5 billion, and these sums were paid out ostensibly as refunds of Danish withholding tax to those who Skat claimed in 2018 had no entitlement to them. And the claim against EDFM amounted to about 5% of the value of the total claims. The allegation against EDFM in the 2018 proceedings were of negligent misrepresentation. And as against all the other defendants, the claims were of fraudulent misrepresentation or that the underlying refund application was fraudulent in nature. In April 2021, Mr. Justice Andrew Baker dismissed all of these claims on a preliminary issue. He found that they fell foul of the Foreign Revenue Rule, DICE Rule 3, that is, that the courts will not enforce a claim to foreign tax revenues. That was his finding. And Skat appealed to the Court of Appeal against that ruling on two grounds against all the other defendants, but we only appealed on the second ground in relation to EDFM. And ground one, against all the others, but not EDFM, was that the judge was wrong to conclude that the proceedings fell within the proper scope of the Foreign Revenue Rule, as stated in DICE Rule 3. That ground, as I say, was not pursued against EDFM. And the reason why it was not pursued as against EDFM is set out in Lord Justice Nuge's judgment below, paragraphs 30 to 31. Skat took, as it describes it, a pragmatic approach. It focused on what it saw as the main defendants against whom it took the view it had evidence to sustain an allegation of fraud. And it didn't then have that evidence as against EDFM. And the EDFM case was more complicated in that Skat could not plead that there were no shares involved in the EDFM case.
But that's the position is different now.
Yes.
Both in relation to shares and in relation
yes,
to fraud.
indeed. Skat's 2022 proceedings, which I will come on to, do allege against EDFM both fraud and indeed as an element of fraud that there never were any relevant shares. There was no dividends. and there was no tax, there was consequently no tax withheld. That's our case in 2022, but I'll come on to that if I may.
And just in terms of the vouchers, were there 420 vouchers in all relating to EDFM in the 2018 proceedings covered by the negligent misrepresentation claim?
That is right.
And so how many vouchers are there in the 2022 proceedings? Is it 425?
There are now 281 of the 420.
And the 5 new
And
ones.
there are, precisely, there are
five
5 new vouchers, new in the sense that they were not the subject of the 2018 proceedings.
I'm sorry, there were how many of the original 420?
281.
281
Yes.
plus 5.
Plus 5 ones that were not the subject of the 2018 proceedings. And the reason why there are only 281 of the 420 is because those are the ones in respect of which we take the view that we have evidence of fraud.
So in the 2022 proceedings, that's just fraud,
Yes.
claim in fraud, is it?
Yes, because we accept that the claim for negligence is caught by issue estoppel. Mr. Justice Andrew Baker, I'll come on to this, but that's why now we say we have evidence of fraud and we're pursuing a claim of fraud. There was a second ground of appeal.
Well, sorry, just before you move on, I just wanted to understand why no appeal against EDFM in relation to the first ground. Is that because the argument was that the revenue rule doesn't apply to fraud claims? I'm not quite sure why.
No, the difference was that we took the view, and we were successful, that the foreign revenue rule did not apply, but we did not pursue the argument in relation to a negligence claim that the foreign revenue rule did not apply, because that would have been more complicated. It would have been more complicated because we would have had to persuade the court that the foreign revenue rule did not apply to a negligence claim. We thought we had a properly arguable case, but it was a more complicated case because in relation to EDFM at that time, we could not say that there were no shares, there were no dividends, and there was no tax withheld. It was more complicated. And we took, as was described in the Court of Appeal first time round, we took what we described as a pragmatic view, which is set out at paragraph 31 of Lord Justice Nuge's judgment, and it's paragraph 110.
So was
of
the
our written
difference,
case.
sorry, was the difference not so much fraud or negligence, but that you thought it, or they thought it would be more difficult to show that a claim was not caught by the foreign revenue rule if it was at least possible that there had been shares, there had been dividends, there had been tax, but that where it was clear there were no shares, no dividends, no tax withheld, it was easier to argue that that couldn't possibly be caught by the foreign revenue rule.
Precisely so. And of course, the EDFM case was only 5% of the total. And so we...
They're quite a big total.
Well, it's a substantial sum of money, which is why we're now pursuing EDFM. Right. Nevertheless...
I'm just slightly raising an eyebrow at the pragmatism of abandoning a very large sum of money.
Well, our main concern, and I'm not just speaking on instructions, I'm referring to what was said in the Court of Appeal first time round. Our main concern was to win the foreign revenue case, and we took the view that our best chance of winning that case, having lost before Andrew Baker J, was to pursue the starkest of the cases. And my submission will be that although our decision not to pursue EDFM in the Court of Appeal on the foreign revenue rule first time round may be relevant to abuse of process, which is not an issue before this court. The EDFM lost on that at first instance and in the Court of Appeal, it is not relevant to the question of issue estoppel, because issue estoppel depends on what Andrew Baker found. And the fact that there was no appeal against Andrew Baker doesn't assist one way or the other.
Might it be relevant to your ground 3, though?
Yes, it may. It may. I entirely accept that as well. And I'll deal with ground 3 when I come to it. So that was ground 1. Ground 2, which was pursued against EDFM, was a ground that the claims were, we said, civil and commercial matters under the Brussels recast regulation. Now, we succeeded in the Court of Appeal on ground 1 against the other defendants, but we lost against EDFM on ground 2 in the Court of Appeal. The Court of Appeal did not decide ground 2 against any of the other defendants because it wasn't necessary to do so. And the Court of Appeal's judgment, for the Court's note, is at volume 2 of the documents, tab 22, page 600. Some of the defendants...
Sorry, Lord Pelling, I should mention, we'll all be working from our electronic bundles.
So if I give the page number...
If you just give us the page number in the relevant bundle.
I'm not sure whether my friends are using the hard documents.
By all means, if it's a courtesy to your friends, then you can give
some of the defendants, not of course EDFM, appealed to this court on ground 1, and their appeal was unsuccessful. My Lord Lloyd Jones gave the judgment for the court in that appeal.
And that just concerned the Foreign Revenue Rule?
Yes, it did. It only concerned the Foreign Revenue Rule. It's at page 723 of the documents. The consequence was as set out in the judgment of Lord Justice Nugent below. He sets it out, helpfully, paragraph 36, at page 142. The order, first time round, was that the claim against EDFM, as alleged, was held inadmissible because of the Foreign Revenue Rule. Perhaps we should just glance, if we can, at that. Page 142 of the judgment below. Paragraph 36 of the judgment of Lord Justice Nugent, he says, effect was given to the judgment by an order. This provided as follows: this appeal is allowed, this is the Court of Appeal order, save in relation to ED&F man. As against ED&F man, the appeal is dismissed. The preliminary issue is answered as follows: save as set out in 2b below. None of the claimant's claims, as alleged, are inadmissible under Dicey Rule 3. The claim against ED&F man, as alleged, is inadmissible under Dicey Rule 3. So that was the order of the court. The next development is that that claim against the other defendants went to trial. And the trial was before Mr. Justice Andrew Baker. And he dismissed the claim on the 2nd of October 2025. This is against the other defendants. And on the 30th of January this year, 2 weeks ago, the Court of Appeal granted Skat permission to appeal. That was Lord Justice Popplewell. And the appeal is pending. Meanwhile, on the 5th of December 2022, Skat issued a second claim in the Commercial Court against EDFM. And that claim can be found at page 254 of the documents bundle. That's the current claim. And it's similar to the previous claim in that it alleges that Skat was induced by misrepresentations made by EDFM to pay refunds of withholding tax to those not entitled to them. The distinctions, in particular, are that we now allege against EDFM that the misrepresentations were made fraudulently. We say evidence has become available, which was not available to us in 2018, partly as a result of US proceedings. And there are other distinctions between the 2018 claim and the current claim. They're set out in our written case at paragraphs 32 through to 39. And in particular, this is the answer to my Lady Simler's question, we do allege in the current claim that relevant individuals within EDFM, and this is set out in paragraph 39(4) of our written case, relevant individuals knew that the trades underlying the tax vouchers involved no shares being owned by the clients at any material time, no dividends being received, and no tax being withheld. That's our contention. The respondent applied to strike out the current claim on two grounds. The first was issue estoppel, the second was abuse of process. Mr. Justice Bright, at first instance, and the Court of Appeal dismissed EDFM's abuse of process argument. That failed. And that conclusion is not challenged before this court. On issue estoppel, Mr. Justice Bright held that there was no issue estoppel here. The Court of Appeal allowed EDFM's appeal on issue estoppel. Newey LJ and Popplewell J as to the whole of the claim. Lord Justice Newgy would have allowed the appeal on issue estoppel, save for the 5 tax vouchers which had not featured in the 2018 proceedings. There are 3 grounds of appeal, my lords, my ladies, the first 2 of which I recognise overlap to a substantial extent. And the first 2 grounds of appeal address a finding by the Court of Appeal that the issue for the purposes of issue estoppel, decided by Mr. Justice Andrew Baker, was that the Foreign Revenue Rule applied, they said, to preclude any claim by Skat for the recovery of monies paid out to EDFM by reason of misrepresentations. That's Lord Justice Newey at paragraphs 131 and 135, with whom Lord Justice Popplewell agreed. Lord Justice Newgy put it differently at paragraph 83. He said that what had been decided by Mr. Justice Andrew Baker was that Skat had no claim against EDFM for compensation for the refunds that were paid out on the basis of the allegedly misleading tax vouchers that were pleaded in the 2018 proceedings. In other words, not the 5 new vouchers. So he would have allowed the appeal save for the 5 new tax vouchers. As I say, we have 3 grounds of appeal. By ground 1, we say that the Court of Appeal erred, great respect, in finding an issue estoppel based on Andrew Baker J's legal reasoning as to the scope of the Foreign Revenue Rule. Our case is that an issue estoppel can only be based on the application by the earlier court of its legal reasoning to the particular facts or alleged facts in the case which the earlier court was considering. And as between Skat and EDFM, Andrew Baker J was considering and only considering the alleged negligent misrepresentation pleaded in the 2018 claim. Therefore, we say, the judgment of the learned judge can create no issue estoppel in relation to the 2022 claim, which is a claim for fraud by EDFM, which was not before Mr. Justice Andrew Baker. The respondent's written case, it's paragraph 10, says that we cannot succeed on the 2022 claim without saying that the issue was wrongly determined by Mr. Justice Andrew Baker. And we respond, that begs the question which is at the heart of this appeal, because the question is, what was the issue determined in 2018 proceedings for the purposes of issue estoppel? And our case is that the issue for the purposes of issue estoppel was not the broad principle that was identified by the Court of Appeal in our case. The issue was Andrew Baker J's determination that Skat's allegation of negligent misrepresentation was caught by the Foreign Revenue Rule.
So are you saying both formulations were wrong in
Yes.
ground one?
Yes. They both treat the issue as wider than the application of the law to the facts that were before Mr. Justice Andrew Baker. And Lord Justice Nugee recognised in his judgment, it's paragraph 63, that this point, I quote, raises quite a fundamental question as to the proper scope of the doctrine of issue estoppel. The question is whether a party can be estopped not just by a judge's conclusion on the facts of a particular case, but by the legal principle that he considered led to that conclusion. That's paragraph 63 of Lord Justice Nugee's judgment. Page 91, thank you. By ground two, which I accept is similar, we contend that the Court of Appeal, both formulations, erred in finding an issue estoppel by reference to what it said was fundamental to the legal analysis by Mr. Justice Andrew Baker of the application of the Foreign Revenue Rule. And we say, in the present case, the issue which the Court of Appeal and the respondents say Mr. Justice Andrew Baker determined, the issue is far broader than it was necessary for Andrew Baker J to determine in order to decide the preliminary issue, which concerned only the claims pleaded by Skat in the 2018 proceedings. That is the claim of negligence.
You could have had a negligent misrepresentation claim in which the facts were alleged that there were no shares and no dividends and no withholding tax at all.
Yes, you could, but that
Yes,
wasn't.
But that wasn't. So you say that actually what Andrew Baker decided was a claim which is based on the allegation that there are no shares, no dividends, no withholding tax, is still caught by the Foreign Revenue Rule. But wouldn't then it be a fortiori true that if there were shares and were dividends and had been a refund, that that would also apply.
Yes, but he, in our submission, was deciding whether the Foreign Revenue Rule applied to Skat's claims, quote, as alleged, unquote. And that was the preliminary issue that was before him.
Yes,
and that preliminary issue, as alleged, requires consideration of what it was that Skat was alleging. And taking your ladyship's point, what was not being alleged was fraud. It's as simple as that in our submission. There was no allegation of fraud as against EDFM as at that time. There could have been, but we didn't have the evidence upon which to base such a claim. And although we have to accept that the reasoning of Andrew Baker J was broad, because he was also considering the claims against everyone else who were alleged fraudsters. What matters for the purposes of issue estoppel is what he decided as between Skat and EDFM. And all he was deciding as between Skat and EDFM was the claim as alleged. That's our case.
So if you're right and issue estoppel has to fasten on the facts of the first decision, it comes down to a question of the degree of generality at which the first decision is expressed.
It does. And I will deal with that in due course. But that's the principle. We say issue estoppel is not concerned with identifying a principle of law, general principle of law in the earlier decision. It's concerned with identifying what question in dispute between the parties as at that time was resolved by the earlier decision, which requires the application of the law to the facts that were then in issue in that earlier case. That's how we
Can I just raise a slightly different point, but don't necessarily answer it now, that you say it's as alleged, air quotes, and you stress when you're reading through that the preliminary issue is as alleged. But, I mean, are you saying that it turns on how the preliminary issue was expressed, even if the preliminary issue had been expressed in the way that Mr. Malik put it during oral argument? I would have thought that your case before us would still be the same, however broadly the issue was expressed. Actually, all that he decided was what had been alleged.
Well, your ladyship's correct, because our case is that issue estoppel turns on what was in dispute between the parties, and that identifies and determines what has been decided by the judge for the purposes of issue estoppel. I mean, plainly he decided much more than that. Yeah. For the purposes of issue estoppel, what matters is what was the dispute between the parties in 2018 proceedings.
And I suppose you contest it by saying, what could you have appealed?
Well, I'm coming to that. Precisely so. We could have appealed only the finding which is based upon the matters in dispute between the parties as at that time.
But your grounds don't turn on the formulation of the preliminary issue.
No, but we say it's very helpful because it identifies what was in issue as alleged, simply takes one back, we say correctly, to what was in dispute between the parties in the 2018 proceedings. There's a third ground of appeal.
Wait, sorry, just before you move on to that, can I just get clear? Are the representations now said to be fraudulent the same as the representations that were in the 2018 claim said to be negligent, or is there a change in the representation?
Because we're now alleging, as I said, that there were no shares, there were no dividends, and there was no tax which was withheld. So that is different, and it's all set out in some detail in our written case, and I can take the court to that in detail if necessary, but it is set out in paragraphs 32 to 39 of our written case.
All right, thank you.
There's a third ground of appeal. We say that if we're wrong on grounds 1 and 2, issue estoppel should not bar Skat's current claim because there are, quote, special circumstances. And the court may have seen that it has granted permission to appeal on this third ground, de bene esse, and the reason for that is because we did not raise this third ground in the courts below. And I'll develop briefly at the end of my submissions why we say we should be allowed to argue ground 3, and there are special circumstances here, in particular, that not merely was the judgment of Andrew Baker J wrong in law, but we could not have appealed, this is the point made to me by my lady, we could not have appealed against the broad issue as formulated by the Court of Appeal. We could have only have appealed against the decision in the 2018 proceedings. It may be helpful just to see what was the preliminary issue, taking my Lady Rose's point, but the preliminary issue appears in the judgment of the Court of Appeal at page 138, paragraph 21. Paragraph 21 on page 138 under the heading the revenue rule. This was the preliminary issue, the first preliminary issue which his lordship identified. Are any of Skat's claims as alleged inadmissible in this court under the rule of law stated as Dicey Rule 3? And the respondents make a point, paragraph 26 of their written case, contrary to what they say with respect, we're not suggesting the inclusion of the words as alleged oust the operation of issue estoppel. That's not our contention. The point we're making is that issue estoppel, as I've submitted, is confined by reference to the application of the law to the alleged facts, because there are no findings of fact, the alleged facts of the case before the first court. That's our submission. The respondents also emphasise in the preliminary issue the words at the end of the preliminary issue, and why. And we do not dispute that Andrew Baker's answer to the question why is relevant to the issue estoppel. Our submission is that his answer to that question, that is, why were the claims alleged in the 2018 proceedings inadmissible under the Foreign Revenue Rule, is, for the purposes of issue estoppel, confined to the allegations that we were making, what was in dispute in the 2018 proceedings.
And the fact that Andrew Baker J considered wider grounds in relation to other defendants is neither here nor there. Precisely so, because issue estoppel can only be based, as your Lordship appreciates, the court appreciates, on what is found as between the parties, that is, the parties to the present proceedings. Issue estoppel is confined to what was decided as between the same parties in the earlier proceedings. So it is a fact that he also dealt with fraudulent allegations of fraud as against other defendants, but that is, with respect, irrelevant. Can I show the court how the courts below dealt with the question of issue estoppel, starting, if I may, with the judgment of Mr. Justice Bright. And this can be found starting at page 175 of the bundle. And can I ask the court, please, to look at page 181 in the judgment of Mr. Justice Bright, dealing with the issue estoppel point. And it's paragraph 44. Well, starting at 43, I asked Mr. Malik what the issue was that was precisely identical
And his answer was whether Skat's claims for compensation for making tax refunds it was not obliged to make was a foreign revenue claim. And Mr. Justice Bright said the problem with this, from EDF Mann's point of view, is that the claims for compensation in the original proceedings were not the same as the claim now pursued in 2022. Put shortly, the former claims were for negligent misrepresentation, the latter for deceit. As Mr. Malik fairly acknowledged, those are different causes of action. And at 48...
And sorry, just going back to your previous answer to me, and I think you're saying, and therefore different representations as well.
Yes.
Right.
Yes. Okay. At 48, the issue as between Skat's and EDF Mann in the revenue rule trial was similar to the analogous revenue rule issue that in principle arises on the 2022 proceedings, but the two are not identical. It's certainly possible to infer or deduce both how Andrew Baker would have decided the latter issue and how the Court of Appeal and the Supreme Court would have decided it. Each tribunal would have come to the same decision as it did on the claims that were in fact alleged. Distinction between negligent misrepresentation and fraud would have made no difference. However, says Mr. Justice Bright, mere similarity and a possible inference or deduction is not sufficient to bring into play the doctrine of issue estoppel. So that was the finding of the first judge, Mr. Justice Bright. We then go to the Court of Appeal judgment, which begins at documents page 133. If the court please would turn to page 149 at paragraph 60, the court will see that this is Lord Justice Nugee who gave the first judgment. He was the allow the appeal save for the 5 new vouchers. Paragraph 60, in the light of the authorities, I'm not surprised that Mr. Justice Bright asked Mr. Malik what the issue was that was precisely identical, nor am I surprised that when Mr. Malik formulated the issue as he did, namely whether Skat's claims for compensation for making tax refunds were not obliged to make was a foreign revenue claim, the judge concluded that the issues in the two set of proceedings were not precisely identical. What Andrew Baker J was concerned with in 2018 proceedings was whether the claims for compensation were foreign revenue claims, but the claims brought in the current proceedings are not the same claims. That is not disputed. The causes of action are different, being framed in deceit rather than negligence, and involve different allegations. That's my Lord Sales's point. Indeed, if the causes of action had been the same, there would have been no question to consider the question of issue estoppel at all, as there would have been cause of action estoppel. So the decision of Andrew Baker J that Skat's claims were caught by the foreign revenue is self-evidently not a decision that Skat's different claims in the current proceedings are also caught by the rules. So formulated, the issues are indeed different and not precisely identical. Then at paragraph 61, Lord Justice Nugee says, in this Court of Appeal, EDFM's grounds of appeal formulated what was said to be the identical issue raised in the proceedings and the current proceedings in similar terms. Whether the claimant's claims for compensation for making tax refunds the claimant was not obliged to make are foreign revenue claims and therefore inadmissible. And Lord Justice Nugee says that suffers from the same difficulties identified by Mr. Justice Bright. The question whether Skat's claims brought against EDFM in the 2018 proceedings were foreign revenue claims is not the same question as whether their claims brought in the current proceedings are foreign revenue claims, because the claims are not the same claims. And then at 62, we see that matters changed in oral argument. In the course of oral argument, it became clear that what really underlies this ground of appeal is a more ambitious contention, which is that what Andrew Baker J decided is that any claim by Skat for compensation for making tax refunds it was not obliged to make is a foreign revenue claim, or as Mr. Malik formulated the issue in the course of argument, we emphasise any, 2 private law claims to recover refunds paid out by Skat based on applications conveying misinformation amount to enforcement of a foreign revenue rule. It's not really disputed that Andrew Baker did decide that and held that such claims do fall foul of the foreign revenue rule. And then there's some detail which the court can read. And at the end of the paragraph, but if Skat is stopped from disputing that any claim by it for compensation for being misled into paying out tax refunds to those not entitled to them is caught by the foreign revenue rule, it cannot now pursue them. And then there's the paragraph I mentioned that this raises quite a fundamental issue. And I'll come back, if I may, to Lord Justice Newgee, but if I then go to the majority, which is Newey LJ, with whom Popplewell LJ agreed, Lord Justice Newey's approach is at paragraph 131, and his lordship says on page 167, in the present case, as Lord Justice Newgee has explained in what I've read, there's no real dispute that Andrew Baker decided that private law claims to recover refunds paid out based on applications conveying misrepresentation amount to enforcement of a foreign revenue rule, nor can there be any doubt his conclusion on this point was fundamental to his overall decision. Far from being subsidiary or collateral, that was essentially the basis on which he determined what was before him. And similarly, at 135, on page 169, the last 7 or 8 lines, he says, but in any event, the proposition that private law claims to recover refunds paid out by Skat based on applications conveying misinformation amount to enforcement of a foreign revenue rule is not a pure point of law. It relates the foreign revenue rule to a factual situation, one where Skat is seeking to recover refunds paid out on the basis of applications conveying misinformation. And we say that the formulation of the issue by the majority of the Court of Appeal, that's Newey LJ at 131 and 135, with whom Lord Justice Popplewell agreed, is in substance a point of law, and it cannot provide the basis for, we say, for an issue estoppel. It's the formulation of a legal principle or legal reasoning as opposed to the application of legal principle or legal reasoning to the particular facts of the case which His Lordship Andrew Baker J was deciding. And we say that submission, I'll come back to Lord Justice Newgee, the minority, in a moment. We say that the formulation by the majority that it's a point of law is supported by a number of factors. We point out, first of all, and we've shown the court this, it is much wider than the order made by the court after the revenue rule trial, because the order was that the claimant's claims in the proceedings are dismissed. That's volume 2, page 18, page 574. Order made by Mr. Justice Andrew Baker. Perhaps we should just look at that. Page 57, it starts at 572. And at 574, near the bottom of the page, we see what is ordered, and what Andrew Baker J ordered is that the claims in the consolidated proceedings are dismissed. That's what he was deciding. And similarly, the order made by the Court of Appeal, after it allowed the appeal in relation to the other defendants is at 578 at the bottom of the page over to 579, and at the top of 579 we see that the claim against EDF Man as alleged is inadmissible under Dicey Rule 3. So the order of the court accurately reflects what was decided. And what was decided as between Skat and EDFM was based upon the claims that were then brought. That's the first point. The Court of Appeal's analysis means that Andrew Baker J decided a much wider issue than the preliminary issue he had ordered to be tried and which he decided. There's a second point, which is that the Court of Appeal's formulation of the issue decided by Andrew Baker J contradicts what Andrew Baker J expressly stated he was not deciding, because he expressly stated that he was not deciding whether a claim by Skat seeking to recover refunds it had paid out based on misinformation as to the identity of the applicant were caught by the Foreign Revenue Rule. He said, I'm not deciding whether the Foreign Revenue Rule applies if the misrepresentations apply to identity. And we see this in the judgment of Andrew Baker, which begins at page 196, and it's at paragraph 90 of his lordship's judgment at page 222.
I'm sorry, could you have the reference again, please?
Yes, it's page 222. The judgment of Andrew Baker J begins at page 196, and the relevant passage for this purpose is at 222, paragraph 90. His lordship says, in saying that, I put to one side misrepresentation as to identity, on which it's not necessary to take a view to decide the present case. Mistakes as to identity are conceptually different, etc.
Well, what is the conceptual difference? Is the conceptual difference that, yes, it was actually a tax fund to which somebody was entitled because somebody had held shares, somebody had received dividends from which tax had been withheld, which someone was entitled to a refund, but just not this person?
Well, my answer to your ladyship's question, I hope your ladyship won't think that I'm ducking the question. It's no part of my case to argue that identity cases are or are not conceptually different. I'm simply drawing attention to the fact that Andrew Baker J thought that he wasn't deciding that point. And my point is that the Court of Appeal's attribution to him of a decision that the Foreign Revenue Rule applies to all cases of misrepresentation is simply inconsistent with what he said he was deciding.
I mean, put another way, if misrepresentation as to identity may make a difference, misrepresentation as to ownership of shares or receipt of dividends may make a difference.
They may.
In the same way.
They may. But I'm emphasising that on Lord Justice Newey's formulation, Skat would be unable to recover because Lord Justice Newey's formulation, paragraph 131 of the Court of Appeal judgment, was that any private law claims to recover refunds amount to enforcement of the Foreign Revenue Rule. That's simply not what Andrew Baker J decided. Whether he's right or wrong doesn't really matter. The Court of Appeal's identification of what he decided is simply inconsistent with what he said, and it's equally irrelevant, in my respectful submission, it's irrelevant whether or not there was any question of misrepresentation as to identity in the 2018 proceedings. It was no part of the case. My point is that the Court of Appeal have attributed to Andrew Baker J a broad statement of principle that is inconsistent with what he, Andrew Baker J, thought he was deciding. There's a third reason why we say the Court of Appeal's statement of what...
Sorry, just on that, I'm not quite sure why it matters what he subjectively thought he was deciding, if objectively, going back to my latest question, there is in fact no substantive difference between different forms of misrepresentation, so that the observation made by Mr. Justice Andrew Baker actually sort of isn't coherent in legal terms. Why would it matter that he had made that observation?
Because the Court of Appeal in our case was seeking to identify what it saw as the issue for the purposes of issue estoppel, which was decided by Andrew Baker J. And they look at his judgment and they say this is what he decided. In truth, he decided, subjectively, he decided, because we know he was wrong, so it's not a question of objective law, we know he was wrong.
Well, we know he was wrong generally about
yes.
applications IC Rule 3, yes. But here, in paragraph 90, he was making a different point.
Yes, but if you're seeking...
Now, what I was putting to you is, what if he's wrong about that different point? And actually, there is no sensible, coherent legal distinction to be drawn in the way that he did there.
Well, I'd make the same point with respect, because I would still say that what the Court of Appeal are seeking to identify for the purposes of issue estoppel is what he decided, whether right or wrong. And what he decided was that he was not pronouncing that, quote, any claim for recovery of sums paid over by way of misrepresentation were caught by the Foreign Revenue Rule. He wasn't deciding that. But I won't labour that point, but that's the second point that we make. There's a third point, which is, and this is the point put to me earlier by my Lady Simler, is although Skat could certainly have appealed the finding by Andrew Baker J that the Foreign Revenue Rule applied to defeat Skat's negligence claim as against EDFM, it would not have been open to Skat to appeal against the general proposition formulated by the Court of Appeal at paragraphs 131 and 135 of the judgment of Lord Justice Newey. We can only appeal against the application of the law to the facts of the particular case. And that's set out by Lord Justice Coulson of the Court of Appeal in the Anwar case, authorities, page 1030, paragraph 17.
Suppose there had not been any other defendants. Suppose the 2018 proceedings had just been against EDFM, and all they'd alleged was we don't know whether there were shares or were dividends, but the allegation was you negligently misrepresented to us that the holders of the shares were entitled to a refund of the withholding tax because they were US pension funds, but in fact they weren't. Either they weren't US pension funds or they held them on trust for us, and we're not for EDFM, and EDFM's not a pension fund. So that was the claim, that was the only claim. Mr. Justice Andrew Baker decides that falls within the Foreign Revenue Rule and dismisses it. And there's no appeal against that, but you then issue fresh proceedings alleging now fraud on the basis that there were no shares, no dividends, no withholding tax, and that can't possibly be caught by the Foreign Revenue rule. So then the question would be, would you be prevented from bringing that second claim by the decision dismissing your negligence claim? That's if you strip away everything else. That's the issue.
That's the question.
And you say they may have had an argument, well, we're being vexed twice, you should have thought of fraud before, and then there would be an argument over whether it was a use of process, and they've made that argument and they've lost that argument.
Precisely.
Right, so that's what...
That's where we are, and I'm going to develop what we say are the relevant principles. I'm just at the moment just finishing the submission of what the Court of Appeal attributed to Mr. Justice Andrew Baker. It doesn't actually, with great respect, make sense, and there's a fourth reason why it doesn't make sense, is because on the majority approach, the Skat, there's an issue estoppel that applies even in relation to tax vouchers, which were not the subject of the 2018 proceedings, the 5 tax vouchers. So I mentioned that as well. New GLJ, as I said, took a different approach to the majority of the Court of Appeal, and His Lordship, Lord Justice Nugie's judgment, your Lordships and Ladyships will wish to be aware of paragraph 81, which is on page 155, and paragraph 81, this is Lord Justice Nugie in the minority. He says, I do not consider the question whether any claim by Skat for compensation for having been misled into wrongly paying out refunds to those not entitled to them is caught by the Foreign Revenue Rule is an issue that's capable of giving rise to an issue estoppel. It's not capable, in his view. A decision on such a question is neither a decision on the particular facts nor on the legal quality or legal consequences of facts. It's a proposition of law untethered to any particular facts. And I'm not persuaded that conclusions on pure points of law are capable of giving rise to an estoppel. And we say that's right with respect. 83, he then adds, for the reasons I've given, I do not accept Mr. Malik's reformulated issue, paragraph 61, because it's stated as a general proposition untethered to any particular facts. But he says it can be rewritten, so the proposition is, do claims by Skat against EDFM for compensation for paying out the refunds that it paid out on the basis of the 420 allegedly misleading tax vouchers fall within the Foreign Revenue Rule? And he answers that question in favour of the respondents, because he asked the question at 85, does it make any difference that the claims in the current proceedings are framed in deceit and based on certain representations said to be made fraudulently, whereas the claims in 2018 were framed in negligence and based on misrepresentations said not to be made negligently? And he says no, that's his view. And we respectfully submit that his lordship's analysis for the minority is erroneous in law for much the same reasons as I have articulated in relation to Lord Justice Newey, because the claims are different claims. They're claims for fraud, not for negligence. Andrew Baker's Lord Justice Nugie's formulation suffers from the same problem, that wasn't what was decided by Andrew Baker J. See the order and see the paragraph 90 on identity cases, and also the approach of Lord Justice Nugie means that he, Andrew Baker J., decided so broad a proposition that we could not have appealed against it. We could only have appealed against what was in issue in those proceedings.
The claim which is now, I'm sorry.
Yeah, you go.
The claim which is now advanced arises from exactly the same facts as the original claim, and in the same circumstances. It's the characterization of it which is different.
Well, it's the same facts, only with respect if one ignores that what is now said is that EDFM acted in a fraudulent manner. But I entirely accept that the background context arises from the same primary facts. I accept that, my lord.
But does that just mean the cause of action is different?
Well, no, it means that the allegation that is being made is a different allegation.
Well, what's materially different in the allegations? Give us an example of a materially different issue rather than just different causes of action.
The materially different issue is whether or not whether the defendant, EDFM, acted in a fraudulent manner, whether they had knowledge of the falsity of the representations that they were making. That's what's different. It's fundamentally different.
I don't understand why you focus on that, because everybody accepts that that wouldn't have made any difference to the application of the Foreign Revenue Rule. I can see that what might make a difference to the application of the Foreign Revenue Rule was whether there were actually any shares or dividends or not. So going back to my example of, suppose that you just brought a claim for negligent misrepresentation and you hadn't alleged that there were no shares at all, you just alleged that they negligently represented that the person was entitled to the refund, and that's dismissed as being caught by the Foreign Revenue Rule. You then bring a case in fraud saying there were no shares, and then, assuming you get over the abuse of process point, they would argue, well, it's the same law applies, and you would say, no, we distinguish the facts of this case from the facts of the earlier case, because here we're saying there were no shares, and that means it can't be caught by the Foreign Revenue Rule, whereas previously we were accepting that there were shares and dividends. Wouldn't you have tried to distinguish the two cases on that basis, not the mens rea of EDFM, because that would be more relevant to whether this is actually a claim for clawing back tax or not, which is what the Foreign Revenue Rule is about.
I understand the way your ladyship puts the point, and we certainly do allege in 2022, which we did not allege in 2018, that there were no shares, there was no dividends, there were no tax withheld. We do allege that. But what I, with respect, don't accept is that issue estoppel should be determined by reference to whether it would have made a difference to the reasoning of Andrew Baker J if the case before him had been different, had been differently formulated. That's not the way I put it. I'm prepared to accept, certainly for the purposes of argument here, that it would have made no difference at all. That's not my case. But I will submit that issue estoppel does not allow the second court to infer from a judgment of the first court what the first court would have decided had the claims been different. That's how I put it. And I'm coming on to that, because it's a very important part of my submissions. We're not concerned in issue estoppel with identifying the ratio of the judgment of Mr. Justice Andrew Baker. We're concerned, and only concerned in my submission, with what Andrew Baker J decided. And what he decided was the claim before him, which is fundamentally different from the claim that's now put. Can I seek to develop very briefly?
Yes, sorry, just before you do look, can you just help me with what is the precise difference between Lord Justice Nuge's formulation and Lord Justice New's formulation at paragraph 135?
Yes.
So paragraph 135, page 169.
Difference, as I understand it, is encapsulated in paragraph 83 of Lord Justice Nuge's articulation, because his formulation, Lord Justice Nuge, focuses upon the tax vouchers that were before the first court, whereas Lord Justice Newey adopts a more broad articulation at paragraph 131 and 135.
Yes, I'm looking at 135 because Lord Justice Newey thinks he's come up with a formula which is tethered to facts.
Yes. But it's all and any claims, whereas Lord Justice Nuge is restricting what Andrew Baker decided to the tax vouchers which were before the first court. And that's why Lord Justice Nuge, for his part, would have allowed EDFM's appeal, but not in relation to the 5 tax vouchers which were not before Mr. Justice Andrew Baker.
That's Lord Justice Nuge is confining it to the very transactions that were before the first court.
That's what Lord Justice Nuge focuses upon. Lord Justice Newey is broader in that it's any claim. He says any claim made by Skat for the recovery of sums paid over by reason of misrepresentation.
Any vouchers.
Yes, yes. And one understands with great respect why he says that, because that's the essence of the reasoning of Mr. Justice Andrew Baker. But from Lord Justice Nuge's point of view, issue estoppel has to be focused, as he accepts, on the facts of the case, but he, with respect, focuses only on the facts relating to which vouchers, not the facts relating to what was in dispute between the parties. That's how I understand it.
So Lord Justice Nuge tethers it to the facts, but only tethers it with a temp peg in the vouchers, whereas you say there should be tethered by temp pegs in other things, the vouchers and the cause of action and the...
Well, and a pleading, and I think, and you say, and a pleading, our pleaded case. So, as I understand it, the difference in the formulation, they both think they're tethering it to facts. It's that Lord Justice Newey formulates the facts in a relatively abstract way, not specifically tied to the particular pleaded case, but facts of the nature of the pleaded case.
And Lord Justice Nuge understands the problem, I respectfully submit, but his answer, again with respect, is not adequate.
Yes,
so can I come to what I say are the principles? There are several principles I want to emphasise before I go to the authorities. The first principle is that whether issue estoppel applies does not depend, contrary, I say, to my friend's introduction to his written case, paragraph 1, it does not depend on whether a person can be said to be, quote, vexed twice in respect of the same cause, unquote. Whether issue estoppel applies depends on identifying and applying the criteria and the limits of the principle of issue estoppel. And the phrase vexed twice is certainly a phrase that one can find in the authorities, but Lord Justice Nuge, we say, was correct at paragraph 117, which is on page 164, 117, page 164, and it's in line, starting at line 6. This is Lord Justice Nuge. The principle that a litigant should not be vexed twice in the same matter is a principle of public policy, but it's expressed at a high level of generality. It's one of the principles that underlies the doctrine of Henderson and Henderson abuse, as indeed it underlies all the different types of res judicata. But it is not a practical test of whether there's abuse or not, and I would say whether there's issue estoppel or not. So I don't invite the court to ignore it, but it's not an answer to the problem posed by this case in my submission. The second principle I want to emphasise, and I think I've mentioned this already, is that issue estoppel is not established by the fact, which is emphasised in paragraph 2 of the respondent's written case, that Skat decided not to pursue an appeal against EDFM in relation to the Foreign Revenue Rule. The question for the court is, what did Andrew Baker decide as between the parties for the purposes of issue estoppel? The question is not whether Skat was at fault in failing to pursue an appeal on the Foreign Revenue Rule as against EDFM. And our decision not to appeal against EDFM cannot expand the scope of any issue estoppel that arises from Andrew Baker J's judgment. The question is, what did he decide for the purposes of issue estoppel? I accept, and I've made this point already, that our failure to appeal was certainly relevant to the abuse of process argument, which failed, and I accepted what my Lady Simler put to me, that it may be relevant, and I'll come to it, to special circumstances, but I'll come to that separately. The third principle that I suggest to this court is that issue estoppel is concerned with what has been decided in the earlier judgment in relation to the dispute between the parties. Issue estoppel, I say, is not concerned with identifying the ratio of an earlier judgment and holding the losing party to the legal reasoning of the earlier court. And I respectfully submit that that would be impermissibly to confuse the principle of issue estoppel with the doctrine of precedent. And we respectfully make that criticism of the respondent's approach in its printed case. This appears in many places, but can I invite the court's attention in particular to paragraph 97. I don't know whether the court has this separately.
We have a core bundled document, which I think many of us will be
If the court has it in front of you, I'm grateful. Paragraph 97.
Page 99.
Page 99 of this is the respondent's written case. What they say is determining whether an issue formed a necessary step in the earlier court's reasoning involves the same interpretive exercise as identifying the ratio for the purpose of precedent. That's their case. And we say, and it appears elsewhere, in particular paragraph 16, we go further back. They say, paragraph 16, Andrew Baker's determination of the issue was necessary to the Revenue Rule judgment in that it formed part of the ratio for dismissing, page 81, dismissing the 2018 claim. Now, we say that is, with great respect, a fundamental flaw, because issue estoppel is not concerned with identifying and giving effect to the ratio of an earlier judgment in litigation between the same parties.
And it's a stronger doctrine. I mean,
Precisely.
if issue estoppel applies, it doesn't matter if the law turns out to be wrong or anything like that.
No, precisely so. One's not concerned. It's a confusion, I say respectfully, between the purpose of the doctrine of precedent, which gives effect worldwide,
and may be subject to change if you take something on appeal.
Whereas issue estoppel applies whether the judgment is right or wrong. It only applies to the parties who are concerned. And that issue estoppel is not concerned with identifying the ratio of an earlier decision. Is supported by the judgment of Lord Justice Leggett, as he then was, for the Court of Appeal in the Young Sam case. Can I ask the court to go to page 2044, bundle of authorities, It's a parole board case. Starts at 2044, Queen and the application of Young Sam and parole board, and the relevant paragraphs begin at paragraph 40, which is on page 2066, and that confirms what my Lord of Sales has just put to me. On page 2066, paragraph 40, at G, the doctrine of precedent, which is a structuring principle of the common law, presupposes that what a court decides extends beyond the particular dispute before it, and that from an analysis of a past case, a general proposition can be derived, which has the force of law in later cases. That's known as the ratio. And issue estoppel, by contrast, we say, is not concerned with deriving general propositions of law. It's confined to identifying what was decided in the particular dispute between the parties. And if we turn on, please, to paragraph 49, which is at page 2069, paragraph 49, page 2069, the reference to Cross and Harris, the ratio of the case, this is the second line of paragraph 49, the ratio of the case must be a proposition of law capable of extrapolation to other cases, not a finding of fact. And of course, an issue estoppel can arise from a finding of fact and doesn't, we say, extend to general propositions of law. So that's the second principle that we, or was it the third principle?
Your third preliminary point, I think.
Yes, that was the third principle that we rely upon. The first was X twice. The second was we have to look at what was decided in the... the second was there was no appeal. That doesn't help. The third is that issue estoppel is concerned with what was decided. It's not concerned with finding the ratio of the earlier decision. The fourth principle for which we contend is that because issue estoppel is not concerned with the ratio, because it's not concerned with the ratio of an earlier decision, but with what it actually decided to resolve the dispute between the parties, issue estoppel, we say, cannot be established by drawing an inference as to whether Andrew Baker would have applied the same principle as he found to be in the law to the facts of the 2022 claim as he applied to the facts of the 2018 claim. Such inferential reasoning is certainly appropriate in the doctrine of precedent, where the court seeks to identify the general principle established by the earlier decision, but it's not permissible in the context of issue estoppel, which is confined, we say, to what was actually decided in the earlier proceedings. Now, this is a very long-established principle, and it dates back to the origins of issue estoppel in the Duchess of Kingston's case. There are many modern examples, but can I just remind the court of what was said by the judges in the Duchess of Kingston's case, which you can find beginning at page authorities 1415. And this is the opinion of the judges. It's an opinion, as we see in the left-hand column halfway down. It's the opinion of the Lord Chief Justice of the Court of Common Pleas, having conferred with the rest of the judges present, and they give their unanimous opinion. And the context we see from the left-hand column, paragraph 1, is a suit of jactitation of marriage, which I, for my part, had to look up. What it is an action the court may know, but it's an action against a person for falsely boasting or claiming that they are married to the complainant. That was the nature of the claim. Whether it remains part of the common law, I have no idea. But that's what they're pronouncing upon. And in the right-hand column, they say in the first new paragraph, and the variety of cases relative to judgments being given in evidence in civil suits, these two deductions seem to follow as generally true. And the first I don't think matters. They say secondly, that the judgment of a court of exclusive jurisdiction directly upon the point is in like manner conclusive upon the same matter between the same parties coming incidentally in question in another court for a different purpose. But neither the judgment of a concurrent or exclusive jurisdiction is evidence of any matter which came collaterally in question, though within their jurisdiction, nor of any matter incidentally cognizable, nor, and this is the point, nor of any matter to be inferred by argument from the judgment. And that's the phrase that has been repeatedly cited in later cases, and we say remains very good law. And therefore, the contention which is made by my friends that none of the factual differences between the 2018 proceedings and the current proceedings would make any difference to what Andrew Baker J decided is, with great respect, irrelevant. Whether an issue estoppel arises does not depend on whether his lordship would have applied the same legal reasoning to the claim in the 2022 proceedings. It can safely be inferred that he would indeed have done so, but that is not the point. Issue estoppel is confined, as I've suggested, to what the earlier court decided by reference to the facts of the case before the earlier court. There's a sixth principle on which we rely, and it is...
I thought this was the fifth.
The fifth principle, thank you. There's a fifth principle on which we rely, and that is, we say it's important not to confuse issue estoppel with abuse of process. The public interest in preventing repeated litigation is also addressed by the doctrine of abuse of process. And the court knows, in the present case, Mr. Justice Wright and the Court of Appeal rejected the respondent's arguments by reference to abuse of process. They found that in 2018, Skat did not have evidence to plead fraud, and there's no abuse of process in Skat now, in 2022, seeking to argue that it was induced to pay out sums of money by reason of fraud. And there's no cross-appeal on that finding. So the mischief of repeated litigation is addressed by abuse of process, and that is relevant to the scope of issue estoppel. There's a sixth principle, and it is, we say, that courts should be cautious about expanding the scope of issue estoppel, and that is particularly because the doctrine of issue estoppel, as is its intention, denies a litigant its right of access to the court. That's a right enjoyed at common law, also happens to be a right under Article 6 of the ECHR, but it's a common law right of access to the court. And that is what the respondent is seeking to prevent us from doing in circumstances where we say, they deny, but we say that large sums of money have been obtained by fraudulent misrepresentation. Again, this is a very ancient principle. We see it, for example, in the case, 19th century case of Howlett and Tart, which is to be found at page 1505 of the bundle of authorities, Howlett and Tart, 1861, judgment of the King's Bench, and it's in the context of a claim for rent. But what matters is what is said by their lordships. And if we go to 1510, page 1510, we see there were 4 judges. Mr. Justice Williams at the lower hole punch begins his opinion by saying in the second sentence, without adopting the old maxim that estoppels are odious, it's enough to say the doctrine is not to be extended beyond what there is authority for. Mr. Justice Willis, near the bottom of 1510, is of the same opinion. Over the page at 1511, Mr. Justice Biles, at the end of his judgment, estoppels are not to be extended without authority. And Mr. Justice Keating concurs this is an attempt to extend the doctrine of estoppel far beyond what any of the authorities warrant. A more modern example of the same concern can be seen in the Carl Zeiss case, to which I will return because the respondent relies on it for other purposes.
I mean, I can see the argument against extending the estoppel, but if you put it in terms of it interferes with access to court, I mean, isn't the response you've had access to court?
Yes.
Precisely to argue the point. So why should you have second access to court?
Well, and that is an abuse of process argument. It doesn't, in my submission, assist on the question of what did Mr. Justice Andrew Baker decide. But I understand your lordship.
Yeah, I was just taking issue with your...
I entirely understand your lordship's point. Perhaps more relevantly, then can we look, please, at Carl Zeiss, which the court will find in the authorities bundle starting at page 1164. And there are 2 passages that, for present purposes, I want to draw attention to. It's at page 1228, Lord Reed. 1228. It's page 917 of the law report, 1228 of the bundle. And if I could invite, please, the court's attention to letter C. Lord Reed says the difficulty which I see about issue estoppel is a practical one. Suppose the first case is one of trifling importance, but it involves for one party proof of facts which would be expensive and troublesome, and that party can see the possibility the same point may arise if his opponent later raises a much more important claim. What is he to do? The second case may never be brought, must he go to great trouble and expense to forestall possible plea of issue estoppel if the second case is brought. This doesn't arise in cause of action estoppel. It seems to me there's room for a great deal more thought before we settle the limits of issue estoppel. I have no doubt issue estoppel does exist, etc., etc. There's a recognition of practicalities here. And also at 947, this is the speech of Lord Upjohn, page 1258 of the bundle, page 947 of the law report, and it's just under the letter C. Lord Upjohn refers to what Lord Reed said. He's pointing out there may be many reasons why a litigant in earlier litigation is not pressed, or even for good reason abandoned a particular issue. It would be most unjust to hold him precluded from raising that issue in subsequent litigation. See Lord Morm's observations, to which I'm coming in New Brunswick. All estoppels are not odious, but must be applied so as to work justice, not injustice. And I think the principle of issue estoppel must be applied to the circumstances of the subsequent case with this overriding consideration in mind. So those are the principles, and I've taken time on principles because my friends say, it's paragraph 12 of their written case, that we are presenting, quote, novel arguments in an attempt to escape the ordinary operation of issue estoppel. That's their contention. And we say our arguments are very much based on principle, and they gain substantial support from the authorities to which I now come. And what I'd like to do is to show the court the authorities which we say support our submissions, And I then address, if I have time, the main authorities, or to the extent that I have time, the main authorities on which the respondent relies. And there are many, many cases, and so inevitably I should be selective in what I show the court. And in particular, I want to show the court 3 decisions of the Appellate Committee on which we rely for our submissions. And the first of those is the authority that was referred to by Lord Upjohn in what I just showed the court, the Carl Zeiss case. It's the New Brunswick Railway case. And the court will find that decision of the Appellate Committee starting on page 1823. And I say that this authority recognises in at least 2 of the speeches and also obiter in a 3rd speech that issue estoppel is confined to what was actually decided on the facts in the earlier case, and it does not extend to what can be identified as the legal ratio of the earlier decision. And can I summarise what had happened here? The respondent was arguing that it was entitled to an issue estoppel because there had been prior litigation between the same parties about another bond in the same series of bonds, a question of interpretation. And there had been. And the appellant gave 2 answers to that judgment, to that argument about issue estoppel. The first argument was that the earlier judgment was a default judgment, and so only a narrow application of estoppel was appropriate. But second, the appellant argued that in any event, issue estoppel did not apply because even though the bonds in the earlier litigation were in the same terms, they were different bonds which were not the subject of the existing proceedings. And the Appellate Committee addressed both of those arguments. And can we please begin with Lord Maughan, the Lord Chancellor, and pick up his speech at page 20, which is page 1842 of the bundle. And at the top of the page, his lordship says, if an issue has been distinctly raised and decided in an action in which both parties are represented, it is unjust and unreasonable to permit the same issue to be litigated afresh between the same parties or persons claiming under them. But, in my view, the doctrine cannot be made to extend to presumptions or probabilities as to issues in a second action which may be, and yet cannot be asserted beyond all possible doubt to be, identical with those raised in the previous action. In the earlier action here, the only relevant issue was as to the true construction of the only bond then sued upon, and an allegation that other bonds of the same issue were in precisely the same form would have been irrelevant and improper. In fact, however, the statement of claim contained no such allegation. Nor is it true to assert that all the bonds of such an issue are necessarily in the same terms. The issue of... Can I stop you for a moment? I apologize. We can't hear you. Thank you very much. Yes, I'm reading page 20. I won't read it again. In fact, however, the statement of claim contained no such allegation, nor is it true to assert that all the bonds of such an issue are necessarily in the same terms. The issue of construction in the second action could indeed be proved in the second action to be similar to that decided in the first, but it related to a different cause of action based on other bonds and could not be asserted to be the same issue. So a very narrow approach his lordship is suggesting. However, Lord Maugham did not decide the case on that basis, because at page 21, his lordship says at line 6, "I do not think it necessary to express an opinion as to whether the alleged estoppel would have succeeded if the appellants had appeared in and contested the first action. The judgment in that action, limited in form to a single bond, was pronounced in default of appearance by the defendants." And he says near the bottom of the page, page 1843, 246, 8 lines from the bottom, "In my opinion, we are at least justified in holding that an estoppel based on a default judgment must be very carefully limited. The true principle in such a case would seem to be that the defendant is stopped from setting up in a subsequent action of defence which was necessarily and with complete precision decided by the previous judgment." So that's Lord Moore.
So suppose then that there's an action on the bond, it turns on one bond, it turns on the construction of a term, and the claimant loses because of the construction put on that term by the court. They don't appeal that, but somebody else has the same bond, and they take the matter up to the Court of Appeal, and the Court of Appeal overturns that. We're talking about claimant B overturns, gets that decision overturned, and they win. So claimant A, I think you would accept, couldn't then re-sue on the same bond that the claim was dismissed.
No, they're bound by issue estoppel.
They're bound, right. But if they have other bonds, assuming there's no limitation point, they could sue on those bonds, relying on the Court of Appeal judgment in the other case as authority for what the term actually means. And you say they wouldn't be stopped from doing that because they'd failed to appeal the same point on the first.
Yes, because the other bonds were not in issue in the first set of proceedings. They're different bonds, and it's not permissible, and I'll show the court the other speeches in the same case, it's not permissible to say, well, if the other bonds had been in issue in the first set of proceedings, the same result would have occurred because they're in the same terms. It's not permissible.
Might be a Henderson and Henderson argument.
Oh, yes, there may well be an abuse of process, absolutely. But from the point of view of issue estoppel, it is nothing to the point for the reasons that are put to me for the purposes of argument by my lady. And this is shown again. So Lord Maugham, I don't suggest his lordship decided the case on that basis, because he said it was sufficient to say there was a default judgment.
Well, just in Lord Maugham's formulation, he seemed to leave open the possibility that if the first decision completely excluded the possibility of a further argument, that might be enough, because he puts it in terms of the previous judgment not having excluded all possibility of raising a different point.
Well, he says if it was identical, if the issue is identical, and we would say the issues here are not identical, but clearly he's adopting a narrow view of issue estoppel. How narrow? Perhaps it's unnecessary.
Yeah, I was just focusing on the bit in about 5 lines down on page 1842. In my view, the doctrine cannot be made to extend to presumptions or probabilities as to issues, which in a second action, which may be and yet cannot be asserted beyond all possible doubt to be identical.
Yes, yes. Well,
I just raise it because, I mean, I'm not sure how much might depend on that formulation, but it might be said in this case that I think you have accepted that, in essence, the revenue point would have been identical in other cases.
Yes, but the claim is not identical, and that, in my submission, is what...
No, that I follow, but don't you accept that the revenue rule point, even if there had been other claims formulated before Mr. Justice Andrew Baker, would have been caught by, for a certainty by the revenue rule as formulated and applied by him.
Yes, well, he decided, of course, in relation to other defendants, that the revenue rule did apply to fraud claims. There's no doubt what he, Mr. Justice Andrew Baker, thought. I say that what Lord Malm, if it matters, what he's focusing upon is whether the action is identical as to issues in a second action which are identical. He's not focusing on the reasoning of the first judge. Lord Wright.
Before you move on, I can see that assists you in relation to the 5 new vouchers, but how does it assist you in relation to the 420?
Well, it assists because the claim in the first action and 2018 proceedings was not a claim for fraud. It was a claim purely for negligence. And it cannot be said, applying this principle, that the issue of construction, which was the issue in that case, would have been the same for the new bonds as for the old bonds. And so I submit that the same principle applies. It's not good enough to say that the reasoning of the first judge, not on construction of the bonds, but on the application of the Foreign Revenue Rule, would have been the same whether it was a claim for fraud or a claim for negligence. That's how I put it.
But the 420 vouchers were before the court on the first occasion.
Yes, those vouchers were before the court. The action, which is what is being focused upon by Lord Malm, the action was an action and an allegation that was different. It wasn't the same allegation. And therefore, yes, and Lord Justice Newgee said in the passages I read that everybody accepts that the claims in the 2 proceedings are not the same. They're different. And so I rely upon this passage, obiter though it is, for the principle that it isn't good enough for issue estoppel to say, well, the bonds are identical in the old proceedings and the new proceedings. We can find a principle that was decided by the first court and we'll apply it to the second action concerning different bonds.
So for the 5 new vouchers, you could, I think you would say, now bring an action for negligent misrepresentation in relation to those 5 new vouchers. For the 420 minus 281, the vouchers that you pursued in the first proceedings but you didn't pursue now, presumably you can't allege fraud in relation to those, and you accept that you are stopped from bringing another claim for negligent misrepresentation because you can't take advantage of the Court of Appeal overturning Mr. Justice Andrew Baker's judgment in respect of those 420 minus 281, even though other revenues around the world might be able to.
Yeah, we accept that insofar as Andrew Baker decided, and he did, that the bonds before him, the vouchers before him were raised foreign revenue law problems which were insurmountable, and therefore the claims could not proceed in relation to negligent misrepresentation. We are bound by issue estoppel. Of course I accept that. Our distinction is as to the difference in the claims now compared to 2018, and I'm relying upon Lord Malm because he accepts, obiter I accept, he accepts that it isn't sufficient to argue that the same conclusion would have been reached by the earlier court had it had in front of him the same claim as is now being pursued. That's the first speech. The second speech is from Lord Wright, which is the relevant passage, can be found on page 1860. And in the fourth line on page 1860, Lord Wright says there are grave reasons of convenience why a party should not be held to be bound by every matter of fact or law fundamental to the default judgment. So he's dealing there with the fact that it's a default judgment. In the next paragraph, but, he says, in the present case, it is not necessary to go so far because there is an even stronger reason against admitting the estoppel. It's true the default judgment expressly declares the plaintiffs were entitled to half-yearly interest. I may observe, in my experience, unusual in a default judgment to make a declaration, etc., etc. There was no issue before the court, that's in the earlier proceedings, as to any or all of the 992 bonds now sued upon. The construction of each and any of those bonds was not a traversable issue in the previous action. The appellants could not be charged with the omission to traverse a claim which could not be traversed in that action because it was not before the court. And we say what was not before Mr. Justice Andrew Baker was any claim alleging fraud. It was not a traversable issue in the previous action, and therefore, says Lord Wright, issue estoppel does not apply. Similarly, Lord Romer, who's the third of their lordships, his lordship dealt with the matter under page 1863. At the bottom of the page, if I could ask the court to pick it up 6 lines from the bottom, this is Lord Romer. He says, I'm unable to discover anything in the judgment or in the record of the proceedings in the former action that can stop the appellants from now litigating the question of the amount of interest payable under the 992 bonds sued upon in the present action. In the earlier action, the only question of construction mentioned in the writ or in the statement of claim was one as to the construction of the bond then being sued upon. And the judgment pronounced in default of appearance cannot, in my opinion, be regarded as having determined the question of the construction of the other bonds possessed by the respondents. But that question was never a traversable issue in the action and would not have been a traversable issue even if the action had been fought out upon a defence that merely put in issue the allegations contained in the statement of claim. Had the question of construction been then determined by the court after argument, the decision would no doubt have been followed in any action brought subsequently upon any other bonds in the same form, and would necessarily have been followed had the decision been that of this House. But this would have happened whoever might have been the plaintiff in the action subsequently brought. It would have resulted, however, from the respect paid to authority and not from the application of the doctrine of res judicata. In other words, he's saying there's a distinction between the doctrine of precedent and the doctrine of issue estoppel, which is confined necessarily by what is in issue in the earlier proceedings. In other words, he says, it would have resulted from the fact that in the former action, a precisely similar question had been decided, and not because the same question had been decided. And we rely upon all of that.
And there would be an issue estoppel for the old bond, even if someone thought up a brilliant new argument which had not been deployed in the first action, because
yes,
it's although it's a question of construction, it's not just deciding on the arguments that had been put forward in the old action, it's deciding what those words mean in that bond.
Yes, in the first action in New Brunswick, the court determined the proper construction of a particular bond, and the losing party is stuck with that if it doesn't appeal. I entirely accept that.
Doesn't it go a little bit beyond that, though? I mean, presumably the order is pay the money on this bond. So going back to my leader's question, if someone dreamed up a fancy new argument that hadn't been advanced before, why that bond should not be paid upon, wouldn't the order to pay on the bond actually preclude subsequent proceedings being brought, saying, I've got this new argument?
Yes, because the issue between the parties was not the construction of the bond, it was whether or not there was an obligation on the defendant to pay the plaintiff on that bond, or how much to pay the plaintiff on that. So I take your Lordship's point. I see the force of that. I see the force of that. But what is impermissible for the purposes of issue estoppel, abuse of process is another matter, but and res judicata is another matter. What is impermissible is to treat the judgment as applying to issues that were not before the court on the first occasion. And then Lord Roma, picking it up where I left off, he disapproves what had been said by Lord Shaw for the board in the Hoisted case. In this connection, some reliance was placed by the respondents upon a passage contained in the judgment of the Privy Council delivered by Lord Shaw in Hoisted, who said it's seen from the citation of authority that if in any court of competent jurisdiction a decision is reached, a party is stopped from questioning it in a new legal proceeding. But the principle also extends, said Lord Shaw, to any point, whether of assumption or admission, which was in substance the ratio of and fundamental to the decision. And then Lord Roma says it was sought to treat this passage as an authority for the proposition that the plea of res judicata can successfully be raised whenever it can be shown that a question substantially similar to that being litigated has been decided in an earlier action between the same parties. My lords, I cannot read the words I've just cited as laying down any such proposition, a proposition for which I venture to think no authority can be found in the books. We respectfully agree. It's no doubt true to say that whenever a question has in substance been decided, or has in substance formed the ratio of or been fundamental to the decision in an earlier action between the same parties, each party is stopped from litigating the same question thereafter. But this is very different from saying that he may not thereafter litigate not merely the same question, but a question that is merely substantially similar to the one that has already been decided, if in an action the question of the construction of a particular document has been in substance decided, each party to the action is stopped from subsequently litigating the same question of construction of that particular document, but he's not stopped from subsequently litigating the question of construction of another document, even though the second one be in substantially identical words, for the documents are two distinct documents and the questions of their construction are two distinct questions. And we say the same is true in the present case, where what was determined was no doubt similar, substantially similar, but it concerned a different matter, which was an allegation of negligent misrepresentation. And what is now before the courts is an allegation of misrepresentation, fraudulent in nature, with all the other ingredients that are applicable to that. So I've shown the court three of the judgments in...
Just on that, I mean, why isn't the case similar to what we were just debating? Someone has been ordered to pay on the bond. They have some further thoughts that they might have a different argument why they shouldn't have been ordered to pay on the bond. I think you accepted that issue estoppel would apply, so they were precluded from raising those different arguments, which would have been available to them to traverse the claim. Now, in our case, as I understand it, the Skat's claims are based on the tax vouchers. So vouchers are put into Skat, they read them, they are misled by them. So looking at it from Skat's point of view, it actually doesn't matter whether what the state of mind is of the person putting in the vouchers. It's just that Skat has been misled as to the accuracy and truthfulness of those vouchers. Skat pays out. Now, in paying out on those vouchers, what I'm trying to explore is that not like someone paying out on a bond or being required to pay out on a bond? And what Skat are saying is we should not have been misled to pay out on the vouchers. Either what really affects us was that we were misled. The defendants in the first claim, they say, were negligent in doing the misleading. You want to say now they're fraudulent in doing the misleading. But isn't the key thing that there was misleading, that gave rise to a cause of action causing Skat to pay out, hence the claim in damages? So that if the essence of the claim is we were misled by the vouchers that were put in, why isn't changing the claim from negligence to fraud equivalent to thinking up a new argument after the event in relation to paying out on the bond in this case?
Well, can I give two answers, Your Lordship? First, our case is not the same as New Brunswick because we're not concerned in our case with the distinction between the bond or the instrument that was the subject of the first litigation and a different bond in relation to the second litigation. We're not concerned with that, as Your Lordship puts to me. We're concerned with the same vouchers. But nevertheless, the principle, I submit, is accurately stated by Lord Roma in the passage I read on page 1865, starting at line 6. This is very different from saying that he may not thereafter litigate not the same question, but a question that is merely substantially similar to the one that has already been decided. And I say that the claim that is now put forward is not the same claim for the reasons that I have sought to identify. It is a different claim. It's a claim for fraud as opposed to what was before the court in the 2018 proceedings, which was a claim for negligence.
But I mean, Lord Roma here says each party to the action is stopped from subsequently litigating the same question of construction of that particular document.
Yes.
But I understood you to accept that actually that's too narrow, that if someone thought up a new argument of construction of that particular document later on, they'd still be caught by the issue of estoppel.
Well, it may depend upon what is in issue between the parties. If the claim is a claim for money on a particular bond, on the true construction of that bond, and the plaintiff, the claimant, wins the case, and the court orders you, the defendant, must pay the claimant a certain amount of money on that bond, then I can see the force of the argument that issue estoppel applies, and it's not open to the defendant to think up a fresh argument as to why they shouldn't have to pay the claimant. But what is different here, I say, is that there is a distinction between what was in issue in the first proceedings and what is in issue in the 2022 proceedings, and they are different claims. There is a substantial difference between fraud and negligence, and it is nothing to the point, for the reasons I've sought to identify, that Andrew Baker may well have given. He probably would have given, almost certainly would have given the same answer to the new claim as he gave to the old claim. And the reason for that is it's not what matters is what is in issue between the parties in the first proceedings. And what was in issue, what was traversable, what was decided was merely that you, Skat, cannot bring a claim for negligent misrepresentation.
I suppose what you would say is that in our case, the causes of action are different. A cause of action in negligence is different from a cause of action in deceit. And the difference in the causes of action is reflected in what a defendant facing such a claim would have to traverse in order to defeat that claim. So if you're sued in negligence, you don't have to traverse fraud. It simply isn't an issue in the claim as it's formulated against you. Whereas if you had been sued in fraud, you would have to traverse that. That would be a point that would actually have to be decided to determine whether the other party was liable in fraud or in deceit or not.
It's a fundamental difference in the nature of the proceedings, and as your lordship puts to me, the issues that would be raised by each party. And the focus, I say, for issue estoppel is not on what has been decided as a matter of principle by the first judge. Issue estoppel is limited by what was in dispute in substance between the claimant and the defendant in the first proceedings. And the first proceedings here were limited on the pleadings as to what was traversable to a claim for negligent misrepresentation. And for Andrew Baker to have decided that claim, all he decided for the purposes of issue estoppel was that that claim was defeated by the Foreign Revenue Rule.
But I think if in New Brunswick the reason why the defendant was refusing to pay the bond was because he said, I was induced by your negligent misrepresentation to enter into the bond, and that's why I'm not paying it. That succeeds. Yes, but then the order is that he pays the bond, but he can't then mount an action or can he then mount an action in fraud on that same bond? Or is he bound by the order that he pays the bond?
But if he later, the defendant obtains evidence establishing that the plaintiff acted in a fraudulent manner.
Yes.
Well, my answer is that I can see the argument for issue estoppel in that case on the basis that the order of the court, what the court actually decided, is that you, the defendant, must pay the plaintiff X pounds on this bond. And the difficulty, we say, for the respondent is that what Mr. Justice Andrew Baker decided, and only decided, see the order of the court and the order of the Court of Appeal, is that the claims by Skat, which were claims for negligent misrepresentation, failed by reason of the Foreign Revenue Rule. That's all he decided. He didn't decide any more than that. He didn't decide, it's not like a money claim where the order of the court is you shall pay over X pounds on this bond. If that were what was decided by the court, I see the force of the issue estoppel argument. That's my answer to your ladyship. There are two other judgments in New Brunswick. The fourth member of the appellate committee, Lord Russell, decided the case only on the ground that the earlier decision had been a default judgment. I won't read it out, but it's at page 28. His judgment, his speech doesn't help for our purposes. He focused only on the default judgment. And the fifth member of the appellate committee was Lord Thankerton. And Lord Thankerton gave a very brief speech starting at page 1847 over to 1848, where he says at the top of 1848, in the second place, I agree, for the reasons stated by my noble and learned friends, that the plea of estoppel by reason of the default judgment is ill-founded, which doesn't tell us a great deal. So I say that...
and sorry, just in technical terms of determining the ratio, what was the ratio then? Well, I mean, I'm sure I could do the maths myself. I just was wondering if you...
Well, our submission is that two of their lordships, Lord Wright and Lord Roma, decided that an estoppel based on a previous judgment is confined to a case where the same factual issue is raised in the later proceedings. And it's not sufficient for a party to say that the legal ratio in the first proceedings determines the point in the second proceedings. A third of their lordships, Lord Malm, expressed strong support for the same principle, but he didn't decide the point. And Lord Justice Nugee said in the present case, paragraph 79, he said it's unnecessary to consider whether what Lord Roma and Lord Wright said technically form part of the ratio. It suffices, he said, that it is, quote, valuable guidance on the true scope of the doctrine of estoppel.
All right.
I mean, the difficulty is it's not clear from Lord Thankerson's brief statement at the top of 1848 what he was agreeing with. He agreed with the reasons stated by my noble and learned friends that the plea of estoppel by reason of the default judgment is ill-founded. Was he confining himself to the reasoning by reference to a default judgment, or was default judgment merely a description of what they were looking at? That's the problem. There's the famous A.P. Herbert story where two of the judges allow the appeal to, and they each say the answer is obvious, and the fifth gives a very brief judgment. I agree that the answer is obvious, and he dies, and so we don't know. Happily, that wasn't the case.
Okay, we can puzzle about that in our spare time.
The court may think it isn't actually going to assist very much trying to identify what Lord Thankerson meant, but if necessary, I do say that's the ratio. We put together Lord Roma and Lord Wright. We put them together with Lord Thankerson, and we put them together with the obiter comments of Lord Malm. It's very strongly influential in my submission. So that's the first of the authorities that I draw to the attention of the court. My friends contend, it's paragraph 74 of their written case, that the Appellate Committee in New Brunswick and some other authorities were not actually applying issue estoppel at all. They say that they were applying the predecessor doctrine, estoppel by record. And I won't read out the paragraphs, but it's paragraphs 74, 78, and 79. They suggest this is a doctrine distinct from issue estoppel, an historical doctrine based on the pleadings. Well, there are three answers to that submission, which incidentally was not a submission made in the Court of Appeal, and so is not addressed by the Court of Appeal. The first is that none of the members of the Appellate Committee in New Brunswick referred to estoppel by record, expressly or impliedly. They're focusing on the earlier judgment. That is the declaration given by the earlier court. Of course, the earlier pleadings were relevant, but they're relevant to what the earlier court decided. That's the first point. The second answer is that the Privy Council has rejected the suggestion that New Brunswick was based upon some older system of pleading, and we see that in a case which disapproved, as Lord Roma did in New Brunswick, the hoisted authority. The case that I refer to is Kok Hung, which is at volume 3, it's page 1703 of the bundle of authorities. And the relevant passage in Viscount Radcliffe's advice for the board is to be found at page 1722. And in the middle of the page, there's a reference to Howlett and Tart, which I showed to the court on be careful not to expand estoppel beyond authority. And Viscount Radcliffe says, and that was page 1505 of the bundle, fortunately, Howlett and Tart has twice been reconsidered in much more recent cases of high authority. One is Hoisted's case. There it was spoken of as being essentially the product of the older system of pleading and is involving no derogation from the true general principle that for the purposes of estoppel, a judgment stands for every point, whether of assumption or admission, which was in substance the ratio of and fundamental to the decision. The other case is New Brunswick, in which full consideration was given to the authority of Howlett and Tart, and an attempt was made to decide to what extent it represented a principle of general application for the purposes of modern litigation. In their lordships' opinion, New Brunswick can be taken as containing an authoritative reinterpretation of the principle of Howlett and Tart in simpler and less specialised terms. The reinterpretation amounts to saying that default judgments, although capable of giving rise to estoppels, must always be scrutinised with extreme particularity for the purpose of ascertaining the bare essence of what they must necessarily have decided. And the reason why Viscount Radcliffe focuses on default judgments is because that was what the case before him concerned. See page 1720 at the beginning of Viscount Radcliffe's advice in the 7th line. They were concerned with the proper limitations of a default judgment as foundation for an estoppel. So I'm not suggesting that Cock-Hoon approved the wider statements in New Brunswick. I'm simply referring to Cock-Hoon because it rejects the suggestion that New Brunswick was decided by reference to some older system of pleading, which is essentially the estoppel by record argument. That's simply, with great respect, simply wrong. There's a third reason.
Also, insofar as there's a conflict between Hoisted and New Brunswick, they prefer New Brunswick.
Precisely so, as had done Lord Roma, and there's many other cases which I will mention where that is also true. Hoisted is disapproved by Viscount Radcliffe. It's disapproved in other cases, such as CAFOR, which is page 1143, and there are other examples as well. Hoisted has no authority, and indeed Hoisted was decided just after another Privy Council case, which decided precisely the opposite in the tax context, Broken Hill, which is in the supplementary authorities, page 3. And Hoisted did not mention Broken Hill, which had been decided a couple of months earlier. So it's not a very persuasive authority. There's a third reason why the estoppel by record argument is, with respect, not to be followed. And that's because the principle of estoppel by record, insofar as it is distinct from res judicata, based on the pleadings, not on the judgments, had passed into history by 1938, when New Brunswick was decided. It wasn't any longer adopted by the law. And the best evidence of that is the first edition of Spencer Bauer, the Doctrine of Res Judicata. Can I ask the court, please, to look at that, which is in the supplementary bundle of authorities? I hope the court received a supplementary bundle.
Yes, we did.
And if, please, you go in that to page 297, you will find the first page of the first edition of Spencer Bauer, with a no doubt illuminating Greek quotation from Sophocles' Ajax, which I can't help the court with, the limits of my education. But if you go to page 298, paragraph 2 in the introduction, in the first place, the judicial decision stops or precludes any party to the litigation from afterwards disputing against any other party thereto the correction of the decision in law or fact. This kind of estoppel is sometimes described as estoppel by record, an extremely inconvenient and misleading expression which accordingly in this treatise will be sedulously avoided. And there's even stronger language on page 300 where there's a further reference.
But I mean, that's not saying it doesn't exist. He just doesn't like the expression.
No, but he doesn't like it because it focuses attention on the record rather than the judgment. That's the concern. And we see this at paragraph 10 on page 300, where he says it is the res judicata, not the record of it, which creates the estoppel. That's the point. Paragraph 10 on page 300. And we say that's right. It is the res judicata, in other words, the decision of the court, not the record of it, which creates the estoppel. And then 4 lines down, accordingly, in this treatise, the expression estoppel by matter of record or estoppel by record will be avoided. The term as applied by Cook and other Elizabethan jurists did undoubtedly reflect the views then obtaining as to the characteristics and limits of this class of estoppel at a time when it was considered a sacrilege to question the inviolable credit and verity of a judicial record rather than injustice and scandal to impeach and re-agitate a judicial decision. The phrase was natural and appropriate enough, but now that the latter aspect of the question, that's the focus on the decision, has gradually but utterly and completely superseded and obliterated the former, retention of the expression has become a ridiculous and archaic survival. So if one
but the judicial record there doesn't seem to be the pleadings, as you were suggesting. It seems to be
the judgment,
some record in which decisions of the court were.
Yes, but what matters is the judgment. That's what matters. That's the point. If one leaves out the language that one wouldn't find in the Law Quarterly Review, language of abuse, the point that he's making is that estoppel by record is not a helpful expression because it focuses attention away from what matters, which is what did the court decide. Of course, in identifying what the court decided, it's very helpful to look at the pleadings because that helps to identify what the decision of the court concerned.
When he refers to res judicata, is that an expression which comprehends both the narrow doctrine of res judicata as we would understand it and issue estoppel, or is it just the narrow doctrine of res judicata?
No, res judicata, as we can see from later judgments, refers to cause of action estoppel and issue estoppel.
So it's the wider portfolio term. Right.
And to some extent covers abuse of process, but it's primarily concerned with estoppel based on the judgment of the court. But in any event, I say there's nothing in New Brunswick which suggests that it can be relegated by reference to what was by 1924, and certainly by 1938, a very antiquated way of looking at things. New Brunswick stands for what it decided, which was that an issue estoppel is to be narrowly focused on what was actually decided in the first case. We've put in a much more detailed, I hope not over-detailed, note on estoppel by record because this point was first raised, and I don't complain about it, but was first raised as a matter of fact in the respondent's written case. So we haven't dealt with it in our written case. It wasn't a feature of the Court of Appeal argument or judgments.
We've received your note and we gave you permission.
Lordship, the court very kindly gave us permission, but I don't want to take time, well, I don't have time to take on that. There's a second appellate committee authority which the court will wish to be aware of, and it's again an authority, we say, that establishes that an estoppel can only be based on what was necessary to decide the earlier case in the light of the issues arising in the earlier proceedings. And it's the appellate committee decision in the case of Concha C-O-N-C-H-A, and it is to be found at page 13 of the authorities bundle, and as the opening sentences of the head note at 1313 state, this concerned the executors of Mr. Concha's will applying to the court for probate to be granted to them. And in their declaration in support of that suit, the executors alleged that Mr. Concha was domiciled in England. Mr. Concha's daughter said no, Mr. Concha was domiciled in Chile, and his will had not been executed in accordance with the requirements of Chilean law. And the probate judge found that Mr. Concha was domiciled in this country. And Lord Herschel, with whom the other of their lordships agreed, noted at page 550 in the first new paragraph, page 1322, page 1322 of the bundle, in the first new paragraph, Lord Herschel says, in addition to the language that I've read, the order contains these words, and that the said deceased was at the time of the date of the said will, and also at the time of his death, a domiciled Englishman. And the daughter then brought further proceedings contending that notwithstanding that order, the deceased was domiciled in Chile. And the appellate committee held that there was no issue estoppel, and that was because it was not necessary for the judge to have decided the question of domicile in the earlier proceedings. And there were two arguments. The first was estoppel in rem, which Lord Herschel addresses at 1323 in the first new paragraph, and I will not focus on that. And then at 13...
Was the point that all that the probate judge had to decide was that he had not been domiciled in Chile, whereas what he actually wrote was he was domiciled in England, but he didn't have to decide whether he was domiciled in England. All he had to decide was that he wasn't domiciled in Chile. Was that the point?
I think, and I'm going to check this, that it wasn't for the probate judge to decide at all where the deceased was domiciled. It was none of his business for the purposes of those proceedings. But can we just look at what Lord Herschel said? Because he turns to estoppel between the parties at 1324 in the two-thirds of the way down the page. And his decision, 1325, at the bottom of the page, but, he says, I think that that must be limited to the matters necessarily, he's talking about issue estoppel, must be limited to the matters necessarily decided in the litigation to which the executors are parties, and if the executors choose, as it said here they've chosen, to obtain a decision of the court upon a point which is immaterial.
Sorry, Lord Canning, where are you reading?
I'm sorry, I'm at 1326. Ah. I'm starting at the bottom of 1325, last two words, but
right.
I think that, and that's issue estoppel, must be limited to matters necessarily decided in the litigation to which the executors are parties. And if the executors choose, as it said here they have chosen, to obtain a decision of the court upon a point which is immaterial for the purpose of determining the rights in question between the parties, they cannot, by tendering for decision an issue which is unnecessary for the determination of the case, bind all parties claiming under the will, because that finding has been obtained in such a suit under such circumstance. That really is the present case. If the residuary legatee is bound here at all, he's bound by a finding of the learned judge, which was quite unnecessary for the determination of what he had to decide, and by a finding of the learned judge, which therefore could not successfully be appealed against. And in the next paragraph, 4 lines down, I cannot see that Adelinda could any more be, she's the daughter, could any more be bound by the determination of the suit of an issue tendered by the executors not necessary for the ultimate decision of that which the judge had to decide, which was solely this: are the executors entitled to probate of this will? And I rely on that because I say that what the Court of Appeal in our case has attributed to Andrew Baker J, that is, you, Skat, either cannot bring any claim for misrepresentation based on payments out to EDFM, or new GLJ, you cannot bring any claim based upon these vouchers, is wider than what Andrew Baker J needed to decide in order to determine the issue before him. And all he needed to decide was that the claims brought by Skat against EDFM were claims, that's claims for negligent misrepresentation, which were caught by the Foreign Revenue Rule. That's why I rely upon this. Issue estoppel is, I say, a narrow doctrine in that sense. And there are other judgments, but they all agree with what the Lord Chancellor said. So that's the second case that I rely upon. I noticed the time. The third one is the more recent case of the Senna.
Shall we deal with that after the short adjourn?
In your Lordship's hands.
Very well. We'll rise now and presume it too.
Thank you, Mr.